Hello, everybody. My name is David Parratt, QC. I'm a member of Three Paper Buildings Barristers in London. And it gives me great pleasure today to be joined by my colleague, Philip Bambagiotti, also a barrister at 3PB, to discuss a topic which is of some concern to the construction industry and more generally to the public, which is aluminium composite panel cladding or aluminium cladding, and what to do about it in construction going forwards. Philip, can I ask you just a general question to start with? We're all aware of the issues of aluminium cladding and the problems that have arisen after Grenfell and the terrible images of fires. But from a legal perspective, Philip, how did our present situation come about?
Thank you, David. That's a very good question and a very important question. The problems with our aluminium cladding arose because in the context of the increasing degree of regulation that is imposed on the construction industry, there emerged in the mid-70s a product that seemed to be a wonder product, something that was cheap, effective, looked good, was a short-term easy fix to turning old decrepit looking buildings into something modern and flashy and new. It was a product that seemed to almost like a MacGyver product that solved a number of problems at once. It was an easy component-driven solution that provided not only an external facade, but acoustic insulation and heat insulation, and it solved a lot of those activities that ordinarily cost a lot of money. Because it was so good, the problem with it emerged that what was known at the time of its dangers and limitations about flammability meant that it was like looking a gift horse in the mouth. And too many of the regulators and those who were responsible for specifying and using the product didn't look close enough at the downside effects to it, such as combustibility. And the combustibility aspect of it was only realizable if you went through a lot of testing that was awkward and inconvenient. And so those who were, or those who should have been aware and risen the flag warning about the dangers were dissuaded, because how can any one individual stand against a public opinion? And as a result of that, it meant that a product that had inherent dangers were used without those dangers being either appreciated or recognised in many ways. From a legal perspective, it poses some real problems, or rather, it highlights the real problems inherent in our building regulation law. The common law relating to building regulation is very much a transactional based law between proprietor and builder. And the regulatory approach has been simply to create refinements on that relationship. And as a result, the common law does not deal well with situations in which the shortcomings and breaches of contract affect people beyond that contractual relationship. The best example of that is the very archaic and limited approach that the common law takes to the question of economic loss for latent defects in buildings, where the injury is not received by the original proprietor, but received by purchasers down the line.
So Philip, before we come to that, those watching this might be wondering, is all aluminium cladding combustible?
No, and that's part of the problem. The combustibility element in aluminium cladding is primarily the polyethylene interior. So an aluminium panel is effectively a sandwich. You have a polyethylene or mixed polyethylene with other products core that is faced on either side, usually with aluminium, but sometimes with other metals. The aluminium is by and large not combustible and was seen as being protective so that the fire wouldn't reach the core and burn it. Well, that's been found to be a false assumption.
Yeah.
There is another problem that has been mentioned a lot, including in the Grenfell fire inquiry, but hasn't really been explored, and that is what's called panel coating. And that is where you've got a panel with the non-combustible aluminium elements, a combustible core, and a lacquer or other coating on the outside that may or may not be combustible. With respect to the core, the problem is that the core is usually a combination of combustible product and non-combustible. So depending upon the percentage composition of combustible component, usually polyethylene, will depend upon whether the cladding product is combustible or not. It's a long way of saying that sometimes they are and sometimes they are not. In New South Wales, for example, polyethylene panel of 30% is regarded as combustible. So the debate is, what do you do with a 29%?
So that then leads me to wonder, Philip, if builders historically put aluminium cladding onto buildings, that wasn't a defective or latent defect product at the time, whereas now it would be considered to be defective. Is that fair?
Yes, and that's one of the main problems that this raises, because in some instances, this product has been suggested or even specified by local councils or public authorities because it was perceived as being a modern, cheap solution to a lot of problems. And it was only a relatively small group within the industry who were aware or should have been aware of the problem. So what do you do about using a product that was thought to be perfectly sound as a pound at the time that turns out to be catastrophically bad?
So I live in a flat. And if I live in a flat in a tower block, and I buy my flat, and at the time nothing is flagged, there's no issue about defects in the fabric of the building, and then this happens, and it's going to put me in a very difficult situation, is it not? That my flat is not worth very much because it's surrounded in a defective product. What do I do?
Well, it could actually be more serious than that, David, because there are a number of regulations that would require the occupants of the flat or their owners to dip into funds to remove and replace the dangerous cladding.
Oh, crikey.
The presence of the dangerous cladding may be regarded and has been regarded by the insurers as being an unreasonable risk, and so they won't provide insurance. And that's insurance that is mandatory. So they're the direct problems. In the New Providence Tower, for example, the big concern, which was a recent fire in London with aluminium cladding, the recent concern was the cost of rectification was going to bankrupt most of the owners that could effectively turn a quite reasonable and desirable residence in the long run into a ghetto. And that leads us, David, to the legal problem. Because the legal problem is, if you can't reasonably expect the occupants and owners to either have the means or have the responsibility to fix it.
Yeah.
Who do you get to fix it? And there's two options. They either find the person who was at fault and pursue recovery against them to fund the rectification.
Yeah.
Or the government has to fund the rectification, and thereby effectively means that everybody has to pay for this exercise. And there are differences and even building to building differences between buildings that are burdened by cladding where, as you say, nobody knew at the time. And in which case you could regard that as misfortune and properly a target of public response. But you've also got buildings in which there were sophisticated market operators involved who should have known. And what do you do in those situations? Because if those people aren't made accountable, it means either the occupants or the public have to wear the consequences of their failure. And there's an injustice element as well as a diseconomy to that.
I can see that, Philip. And going back in the day when the cladding was installed, was it technically in breach of any regulations?
According to the findings in the phase 1 of the Grenfell inquiry, properly considered, the aluminium cladding used on the Grenfell Tower was always non-compliant with the building code.
Okay, that's important, isn't it? That's important for breach. And
that's
and
right.
Therefore the next, the next question, I suppose, would be, Philip, the next question, I suppose, Philip, would be, what about limitation issues which may arise between the breach of the regulations and the consequences that the property owners you identify now face?
In general terms, you've got a 6-year limitation period for a breach of a contract. That runs from when the contract is breached, regardless of whether you knew of the deficiency. In almost every case, the current owners of these high-rise apartment buildings weren't parties to the contract and weren't able to bring the action within that 6-year period. So in almost every case, they depend upon one of two vehicles to bring those claims. Firstly, where the contracts and other arrangements regarding construction have been novated, and where those contracts use vehicles such as deeds that have a longer limitation period that may or may not be available. The scope for that is fairly limited, although there are some examples. The most obvious course is to use the law of tort, which is the law regulating wrongful actions between parties who don't necessarily sit within the framework of a contract. And that's where we run into the problem that we've got with the approach that the courts have taken to this economic loss tort issue and the availability of relief.
Okay, well, let's explore that, because it seems to me that if there is a breach of the regulations, is there also a breach of a duty of care to the third party who may ultimately purchase the property?
David, you've identified exactly the question that has been asked repeatedly since 1972 in the UK and in Australia. And the question is whether or not the law recognises a duty of care between those that are involved with building a built structure and those that eventually purchase it, occupy it, live in it, and so on. The courts have what has turned out to be a very strange view with respect to that, because they've said if there is a personal injury that arises, then they're prepared to recognise a duty of care.
Mm-hmm.
If there is no personal injury that arises, in
Mm-hmm.
most cases, they refuse to recognise that.
Mm-hmm.
Now, in Canada,
And this is your pure economic loss point.
that's the economic loss point, because where you have a latent defect that emerges after a period of time, and they almost always emerge after that 6-year period, the law regards that deficiency as being an economic loss rather than an actual loss. That is, it's a loss in a value of money relating to the building, and the courts have been very limited
by virtue of the by virtue of the defect, of course.
So the deficiency represents an economic loss you've sustained because your building is worth less, rather than looking at it as a defect as such.
Yes.
Now, in Canada, when this issue was dealt with years ago in a case called Winnipeg Condominiums, it was said that there isn't much sense in saying that you have the ability to claim compensation for a deficiency that emerges, but an inability to claim compensation to fix a deficiency before it injures somebody or kills somebody or causes the damage.
Mm-hmm.
Neither the United Kingdom courts nor many of the other common law courts have an answer to that. Their answer consistently is to push that to one side and not provide relief and remedy. Now, this is a very serious issue because in many cases, by the time some of these deficiencies emerge, they're very high cost, particularly with high-rise apartments, to mend.
Mm-hmm.
And the passage of time means that defendants are difficult to find. And having this imbalance between contractual rights and tortious rights has led to very poor economic outcomes. So in New South Wales in 2020, there was legislation that created a statutory duty of care to benefit property owners that is imposed upon those that were responsible for a building's construction, to enable them to have that tortious relief. And interestingly, I was involved in lobbying for and making that legislation. And interestingly, when the question of whether or not it should be retrospective came up, and I was asked that, my question was to the political people, was shortcutting and deficient behaviour and passing off shoddy work as being good work, was that ever an acceptable behaviour for building professionals? The answer was no. And as a result, that legislation was made retrospective for 10 years.
Right.
And that has met a gap because there's been literally billions of pounds spent in the last 50 years debating every time one of these issues has come up as to whether or not there's a duty of care. Instead of the courts and the lawyers and the parties looking at whether or not there was a breach or whether or not there was unsatisfactory behaviour, all they've been able to look at so far is duty of care. So now in New South Wales, at least, that debate has gone away, but that is a really important debate that maintains in the United Kingdom.
I can see that. And in Australia, when they did this shoddy work, as you put it, was that in breach of the Australian building regulations of the time?
The Australian building regulations are practically speaking identical to those enforcing the UK. The Building Code of Australia, which is the equivalent of the standards that were dealt with in Grenfell, most people, 90% of builders and certifiers and engineers and experts would have said that the aluminium cladding was compliant. The Grenfell finding was, in a sense, a retrospective or a hindsight construction of the standards.
Mm-hmm.
So parties can use that finding as a basis to say that there was a breach.
Mm-hmm.
But there are fairness issues because the knowledge of that breach was fairly narrow at the time.
I can see. What is the name of the statute in Australia from 2020?
It's the Design and Building Practitioners Act 2020, Part 4.
Okay. And what that achieves, Philip, is to impose a statutory duty of care and thereby get round this pure economic loss argument to allow the proprietors to access those who installed the defective within the limitation period of 10 years. Is that it?
No, it's within the limitation period of 6 years from when the deficiency manifests.
Okay.
But it goes back 10 years to building work that was done 10 years ago.
I see. Okay. And have many claims been brought under this act?
Virtually every case that I've got for building defects in our version of the TCC has a Design and Building Practitioners Act component within it.
Okay.
Remembering that the reason that it was framed in the way that it was, dealing with nothing other than the existence of the duty of care, is to recognise that the law of tort has an enormous scope of protections for defendants and builders. The argument, if you look at the cases in the United Kingdom and Australia on it, there is very much a chicken little approach to, oh, if we do this, there'll be no building and nobody will be able to know what to do and blah, blah, blah. And that overlooks the fact that particularly with the tort reforms that occurred in 2003 in Australia, as well as in the UK, a defendant to a tort claim has a significant degree of protection from unreasonable liability. The effect of that act was simply to take the debate as to whether you owe a duty of care out of the equation and allows you to focus on the rest of your case, which isn't just a open season for builders and developers. It requires a lot of work to win those cases, but it just means that everybody's actually talking about what happened on the site rather than academic arguments about duty of care.
Well, it sounds to me as though that act in Australia has been successful in allowing the proprietors a right of relief or an avenue of compensation to go to those who were negligent in the installation of the defective building material.
Yes.
And I suppose I should ask you, Philip, should the UK be doing the same?
Without question. Without question, because the model that the courts use with respect to dealing with these issues, and we're not necessarily talking about directly with builders, we're talking about builders and architects and fire engineers and all of those that are in professions, that learned professions that you would expect to have knowledge and care about the use of these products, and who are engaged to supervise and superintend and certify.
Yeah. The
problem is that in the UK, unless you go down the negligent misrepresentation route, Hedley-Byrne and Heller, you really have no avenue of redress, which means that the economic temptation for people to just sign off and to yield to monetary temptation becomes irresistible because there's no consequence for giving that certificate that doesn't quite accurately reflect, or using a material without quite doing all of the testing that is recommended or required. Had that been done, we wouldn't be in the ACP position. But as I said, the bigger problem is, if we look at aluminium cladding as being a wonder product that everybody accepted was marvellous, that they should have looked more closely into. The bigger question is how many other products that we use now day to day fall into that same boat. The fact that they haven't proven to be combustible yet creates a general sense of uneasiness and disquiet.
I was going to ask you, Philip, obviously aluminium cladding is the wonder product other than this combustibility or flammability. Have things moved on that there is now non-combustible aluminium cladding that can be used?
Yes.
Right.
Yes, there is. So there are now products that don't use polyethylene at all.
Right.
Products, aluminium panel cladding that uses very low percentages of polyethylene, or that are distributed, even the combustible product that is used in a way and distributed throughout the building that doesn't pose the same kind of fire risk. Remembering the problem in Grenfell was that the fire entered the sandwich element of the cladding and was able to rush quickly to the top of the building and then down. And the presence of the aluminium and the other features meant that it couldn't be extinguished. So by splitting the even combustible elements of cladding up, so you resist the movement of the fire, that's a significant advantage. So yes, there are products and steps in place to replace them. The difficulty, though, David, is the cost of getting all the scaffolding and pulling all the cladding down and then putting the new product up, which is huge.
Okay. Now, to conclude, Philip, earlier you were suggesting two avenues of recourse. One would be to address the economic loss issue in tort in the way that Australia has done with the 2020 Act, to get round it that way. Or the alternative you posited was governmental intervention and basically picking up the tab. Which, if you look in your crystal ball, which way do you think the UK will go? Well,
the UK has so far opted for the second route, as indeed has New South Wales, I should point out. So it's been a two-pronged approach. In the United Kingdom, the government have instigated a program whereby the owners and occupants of these buildings are able to get low interest or no interest loans to fund the identification and replacement of aluminium panel cladding. So that takes the urgency of the need to raise the funds away. It doesn't eliminate the problem. So, for example, in the new Providence building, they were in the process of rectification. The fire started days before rectification was meant to commence. So it doesn't alleviate the problem. And there is some criticism that all that it does is impose another very high burden of long-term debt on the homeowners, remembering that the market for this kind of high-rise luxurious buildings in Australia and in London particularly require so much money to buy that the purchaser really doesn't have a lot of spare cash to go around rectifying, and then to add a proportion of debt on top of that affects people's liquidity.
Maybe just one final thought. Those people who are prospective purchasers who are going to buy the flat in the development, is there any recourse against those who they instruct to survey the property and who might have a duty of care to advise them prior to the purchase as to the nature of the cladding? Has that been contemplated?
Yes, that's the other route that is being explored. The problem though, is I think anybody who is in conveyancing now, and when I say conveyancing, I don't mean the conveyancer itself, but also the pre-purchase inspectors and the building surveyors.
Yeah, yeah.
Anybody now would be foolish either not to exclude liability for aluminium cladding, which is what most often happens,
Right,
or to at least recognise and flag it as a possibility, in which case your liability is discharged.
sure.
Part of the problem comes is that the combustible, as opposed to the non-combustible, or as opposed to the less combustible cladding, can sometimes be hard to identify.
Yes.
It can sometimes require invasive inspection. So a visual inspector will very often say, look, there's cladding, it might be non-compliant, it might not be. I didn't take one off, so I don't know. And that will have discharged their duty of care. The problem is that as a purchaser or a consumer, you're ordinarily not a person who is heavily involved in the building industry. So the ordinary consumer is not necessarily able to recognise what that qualification means, how serious and significant that qualification is. And in the light of that qualification, even finding out what to do with it is impossible. It's very hard to get anybody to do a pre-purchase inspection other than a visual one, which means that you're just left in doubt and risk without knowing how to price and categorise that risk. But certainly, they have a responsibility.
Well, that brings us, Philip, to the end of this webinar, this chat that we're having. I find it fascinating. I find it really interesting, both actually from, sadly, the practical point of view for those purchasers or those individuals who are faced with this problem, not of their own making, and it's due to somebody else's fault. But there doesn't seem to be in law, the other side of this, in law, a straightforward right of relief or recourse. So we'll have to wait and see what happens in the UK to see if it follows this this idea of the 2020 Act, which is to me a breakthrough.
Yes, well, but it also means that until those kind of relief, it's almost incumbent upon the legal profession to push the envelope or push the boundaries with respect to economic loss, to do what they can to encourage the courts to recognise the diseconomy and the injustice that this approach of the law currently gives rise to, and hopefully through common law, incremental common law development, achieve it that way. Anyway, thank you. Thank you very much.
Well, thank you. Thank you very much, Philip, for that. And thank you to all those who have been watching. Thank you from 3PB.